Daddy. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning and welcome to the Appeals Court. I am William Meade. To my right is Justice Singh, and to my left is Justice Smith. Will be the panel for all the cases today. If you've been here before, you know the rules. Each side gets 15 minutes. You needn't use all of your time. We have read everything. My best advice is to get right to the point. We do not entertain rebuttal. With that, I'll call our first case. It's 2022 P 1158, Wendt versus Wendt. Mr. Novich.
Good afternoon, members of the panel. My name is Richard Novich, and with me is my partner, Gary Todd, and together we represent William Wendt. Trial court abused his discretion in this case in three respects: in his custodial award, in the division of the marital estate, and in the calculation of child support. I'll address each of those in turn. Custody, without a question, are the most important and often the most difficult cases for trial court judges to decide. As such, trial judges are imbued with substantial discretion. But as cases from this court have highlighted year after year, that discretion is not limitless. Here, strike that, the decision must be supported by findings, specific findings that justify the ultimate conclusions that have been reached. And in this case, those findings are lacking in several material respects. I will not insult you by regurgitating the facts. I know you all have read them or certainly will read them, but just want to highlight one. For the 3 years leading up to the divorce, it was undisputed that the parties shared custody equally with their two children for 3.5 years. That constituted more than half of the life of one of the children and nearly half of the life of their second child, a meaningful part in their lives without question. In those types of situations, the case of custody of Callie teaches that a major focus of the trial judge's consideration should be on, quote, the benefits of stability and continuity. Here, neither of those things appear to have been addressed or even considered at all. Of the trial court judge's 57 findings of fact, only 4 dealt with physical custody. Of those 4, none addressed the benefits of continuing the shared parenting plan. None of those findings addressed how a change of the nature that was decided here would affect the children at all, nor were any of these findings describe how a change in the parenting plan would better serve the children's interests. There also were no findings concerning the children's bonding with either of the parents, or in fact, there really weren't any findings relative to the children at all, other than one of the children had an IEP at one point. Nothing in the very brief, I think it was a 4-paragraph rationale, nothing in the rationale described how the judge reached the conclusion that a dramatic change in the parenting plan outweighed the benefits of preserving it. The trial judge also disregarded evidence having to do with the importance of the children's religious upbringing and Mr. Wendt's participation in that religious upbringing. I don't suggest for a second that the trial court needed to establish a plan that addressed a religion or either of the parties' religion at all. What I'm suggesting is that he needed to at least consider it, given the importance of it in this family and with these children.
Would the remedy there be to change the parenting time or the drop-off pickup? Would that satisfy the religious concerns?
Yes, it could. And in this instance, as I'm sure your honors can recall, even the mother's proposed judgment suggested that the parenting plan run from every Saturday at 3, which incidentally was before the religious services on Saturday, through Monday morning drop-off after the religious services on Sunday. The record evidence demonstrates the importance of religion in the children's lives. I would like to highlight just 5 facts in the record. Number 1, undisputed the children were baptized. They attended Catholic school. They attended church in the 3+ years prior to the divorce only with their father. Church times on Sundays were 4 o'clock on Saturdays and 9 or 10 o'clock on Sundays. Mother testified she did not practice any religion at all. Despite all of these facts, despite the testimony, the trial court judge ended the father's time, not began it, but ended the father's time at 4 o'clock on Saturdays, thereby completely precluding him, strike that, in all but one weekend during the school year. The summers were a little bit different, but during the school year, there was only one weekend during the school year where his time extended to allow him to have.
Counselor, consistent with what Justice Meade asked, father could seek a modification of the time, correct?
Sure, he absolutely could, but I'm not sure if he would be able to satisfy the material and substantial change in circumstance to make a modification of that. He would have to prove something that has changed since the divorce.
It wouldn't be enough to fine-tune these arguments you're making now about the timing. I mean, the timing of the availability of Mass wasn't necessarily a focus of the trial, for instance.
It may not have been the sole focus, but it was certainly included in the testimony of, I think, both parties, certainly my client. And to your point about whether you could seek a modification, he would have to show some change. And under the circumstances of this case, I'm not sure he'd be able to do that because as of the date of the divorce, it was known the children attended church with their dad. It was known what the time of the religious services were. None of that was a mystery. There would be no change in circumstances of those two things. Without explanation, as I said, parenting plan that the judge crafted all but interfered with father's ability to share and participate in the children's religious upbringing at all. Next,
And I know you said the wife had no religious preference, but was there any evidence that she ever brought the children to Mass?
Great question. The answer is no. The pastor or the priest at the church testified that in the 3+ years during their separation leading up to the trial, he didn't see her in church once. She also testified not that she had no denomination or preference. Her testimony was that she did not practice religion at all. She had been raised Catholic or had converted to Catholicism, but as of the time of trial, she testified she did not practice at all. You could find that testimony at the Record Appendix 10, page 260. Next, while Mr. Wendt was far from perfect, I suggest very few parents are perfect. The court certainly, without a doubt, could have considered his imperfections. There's no doubt about that. However, there are no findings in the record, certainly none in the 4 findings that were made, that linked his imperfections to his parenting or linked his imperfections to any adverse or detrimental impact on the children. Now, my brother says in his brief that my client's behavior had a, quote, destabilizing effect on the children. There's no evidence in the record to suggest that at all. There were no findings in the record and no evidence in the record from which a finding could be made that the children ever saw or were even present for or overheard most of what the trial court judge relied on in conversations. No evidence of that. No findings, certainly. And some of the reported conflicts that the judge did rely on took place years earlier, even predated the parties' separation. I would suggest that many of them were stale. The last thing I would like to address on the issue of parenting is that the court appears also to have ignored the fact in the testimony from, I believe it was both husband and wife, that despite my client's imperfections, the children were thriving. Things had improved in school, and she even acknowledged that their communications had improved as of the date of the divorce. In many respects, I suggest this case is very similar to the case of Belanger versus Bottano. I've cited in the brief, it's a 128 decision from 2017, had very similar facts and deficiencies, if you will, in that case, as I suggest happened in this case. Moving along to the asset division.
Before you move on, counsel, the judge did credit the testimony that your client said he would slit the new mother's boyfriend's throat, correct?
Yes.
And he said that in front of the children, correct?
Correct.
And does judge need to draw an explicit line between the detrimental effect that sort of statement may have on young children, or could that be implicit in his findings?
I think under the holding of Shack versus Shack, there'd have to be some evidence to link those two things together. I believe the holding of Shack specifies that in particular, and as Your Honor, I'm sure can recall, Shack versus Shack dealt with a litigant's First Amendment freedom of speech and the nasty things that, in that case, the father had said to the mother in the presence of the children. That was an issue that was confronted in that case. And my recollection of the holding of the SJC was, in order to infringe upon that parent's custodial rights, you would have to demonstrate and prove with evidence of some fashion that there was some adverse impact based on those words on the child. Now, getting back to the asset division piece, as you might imagine, there are many things about my good brother's brief that I disagree with, many things. But there's one I agree with, and that is this. The purpose of property division. I agree with him what he says, and that is, as this court has found time and time again, decade after decade, the purpose of property division is to, quote, equitably compensate parties for their respective contributions to the marital estate. He cites Harris versus Harris. You'll find that in Moriarty versus Stone, which I believe talks in terms of contributions being the touchstone of any equitable division of the marital estate. Here, the trial court judge appears to have given no weight at all to Mr. Went's substantial financial and non-financial contributions, both pre- and post-separation. The evidence was undisputed that during this less than 5-year marriage, he and his family contributed in excess of $3.2 million. For Mrs. Went's part, the evidence at trial was somewhere in the neighborhood of $260,000. Now, I'm not suggesting that there's a mathematical formula that needs to be followed or anything of that nature, but based upon the 57 findings, it doesn't appear to me that the trial court judge truly considered in any fashion the contributions. Despite the contributions that I've just identified, the decision that you have before you allocates, and I think this is important to note, allocates to Ms. Went 100% of her assets, retirement account, pension, bank accounts, what have you, the entirety of the value of her parents' gift of the equity in the house, $260,000, a majority of the appreciation on the house, which I believe all of the funds that were used to renovate came from my client and his family, and nearly 5 years to pay Mr. Went his share of the equity security-free. In contrast, as I believe you'll see in the brief, Mr. Went, until he receives his share of the equity, if at all, if that comes in 5 years, he leaves the marriage with roughly 1% of what he contributed, less than 1% of the $3.2 million. Stated in a different way, if you look at it from a different perspective, the award that he received in this case is 4.5% of the divisible marital estate, 4.5%. The case of Z versus Z, which is cited in the brief, I think that's in a decision of this court from around 1988. In that case, the decision of the trial court was vacated where one of the spouses received 9.5%. And in that case, and in this, I would suggest, the division of assets was, quote, far outside the realm of equitable division and should be vacated. Last, but certainly not least, is the issue about attribution of income to my client and the calculation of child support based thereon. I'll be very brief with this, as I believe the brief that you have sufficiently specifies it. I will just go on to say two things. One, the child support guidelines on their face do not allow a trial court judge to both consider a spouse's actual earnings and attributed earnings. The guidelines specify it's one or the other, not both. And I believe that two panel decisions of this court, Higgins and FICO versus Detler, I think FICO is a 2023 decision, Higgins is 2019, they're both cited in the brief, and I believe that they're both on point and are dispositive. Unless there's any other questions, I'll rest on the arguments in the brief.
Seeing none, thank you.
Thank you, Judge.
Mr. La Rochelle.
Thank you, Your Honor, members of the panel. May it please the court, my name is Dennis La Rochelle, and I'm representing the wife Appellee, mother, Molly went. We'll get right to the issues as you suggested, Justice. One of the aspects of the decision that the husband appeals is the parenting plan. The husband's right. The court did jettison the parenting plan that had been in place throughout the entirety of the litigation and replaced it with one which was better suited for the needs of the children. We don't disagree with the husband's premise that if the parenting plan that's already existing is working well for the children, it should not be replaced. We agree that if it ain't broke, don't fix it. But this parenting plan that was in existence at the time was broken, and it needed to be fixed, and Judge Simons fixed it. Under the parenting plan that existed at the time of trial, when the children were with the father, on 3 days in a row, the father sent one of the children to school with nothing but blueberries for lunch. On the father's parenting time, over the one semester that was looked at, 10 days that the children were with the father, they appeared at school tardy. Now, to put that in context, there's about 100 days in a semester, in a school semester. At the parenting plan at the time had the parents splitting school days 50-50, so the father had 50 days in which he had to get the children to school. 10 out of those 50 days, 20% of the time, he couldn't manage to do that. That's a detriment to the children. Certainly blueberries is a detriment.
I wanted to check the record to make sure I wasn't mistaken, but my memory and my reference to the record is one day where the child went with blueberries for lunch. You're saying there are 3 separate days?
It's 3 days in a row, Your Honor. The teacher testified to that, and the husband also testified on cross-examination that it was 3 days. He said he also gave them a granola bar, but the teacher testified there was no granola bar.
But the judge found 1 day.
I think, well, I'm not sure what the judge put in his findings, actually, but that there were 3. There was at least 1, certainly, and there were 3, actually, according to the testimony. The husband also failed to pick up the children after school on at least 1 occasion in those 100 days, 50 days, which were his. And the children, when they were with him, came to school without the supplies they needed. They were the only kids in the class that didn't have the supplies they needed. So clearly, at least with respect to school days, the judge was right in finding that these children were better served by being with the mother. And that's the plan that he fashioned. 4 out of 5 school days every week, they're going to be with the mother. Indeed, I think the children are better off spending most of their time in general with the mother. There's plenty of findings, much in the testimony and much in the evidence, that indicates that the father had a temper problem. The father had a judgment problem. And these things did affect the children. There's no doubt about that. In one instance, the father discussed with his 7-year-old son, as they were waiting to go in and talk to the pediatrician about the mother's concerns about his younger brother, 5 years old at the time, he asked his 7-year-old son, "You don't think your brother has autism, do you?" Denigrating the mother's concerns, and why would you put a 7-year-old child in the middle of that discussion? It's totally inappropriate. On another occasion, the father ranted while in the pediatrician's office with both the children in the next room. Possible they didn't hear, quite possible they did. He called the mother a child abuser, and he said that she was a crummy mom. I think the exact word was horrible mom. With the children able to hear that. He also, as Your Honor mentioned, he threatened to slit the throat of the mother's boyfriend if he ever came back on the property, with the children both there. And what we do know from the testimony is that the older child ran into his room and closed the door, slammed the door behind him. The younger child was in his mother's arms and he was crying. Well, of course they would. There's no question that the father's behavior is detrimental to the children. Father also picked a fight with the mother's father, who was out in the yard mowing the lawn as he was entitled to, that almost became physical. And that was also done, as the father testified, he didn't know whether his children were looking out the window. It's quite possible. And then he said, well, children, you can't go visit your grandparents anymore. How is that beneficial to the children? So given all that, I think Judge Simons was certainly right in determining that the children are better off spending most of their time with their mother, number one. And number two, certainly almost all their time with their mother on school days. So what he fashioned was a plan that gave the father basically 2 nights every week. 1 weekend a month, he gets 4 nights, and 1 weekend a month, he gets 1 night. So he gets a total of 9 days out of 28, about 1/3 of the time. It's not a drastic change from a 50-50 parenting plan, but it's certainly an appropriate change given what the father was doing to these children.
What about the parenting plan that prevents him from taking the boys to Mass?
The parenting plan, as it exists in the order, in the judgment, certainly does prevent the father from taking the children to Mass. First of all, it doesn't prevent the children from going to Mass.
But no one's taking them to Mass.
I'm sorry?
No one's taking them to Mass.
At the time, according to the judgment, that is true. I don't know if you want to hear what's happened since. I don't think you can hear what's happened since.
It's not on the record. I don't want to hear it.
That's correct.
My concern is that the Supreme Court cases that you rely on don't seem to make the point that you are making. First, you seem to focus on that this is an exercise of the father's religion as opposed to the exercise of his ability as a legal custodian over the religious upbringing of the children. The cases you cite point to religious liberty that the state can't interfere with, like a judge setting a parenting schedule that prevents the father from taking his boys to Mass.
What those cases point to, what the Supreme Court cases say explicitly, is that it's not the state's determination, it is the legal custodian of the child until the child's an adult.
He is a legal custodian, correct?
He's a joint legal custodian, so it should be up to the parents jointly. And I agree with Justice Smith that if the children have been going to Mass, and then after the judgment they stop going to Mass, that is a change of circumstances which would allow, if that was the case, which would allow father to come in and seek a modification. But the court, neither Judge Simons nor this court, should make a decision to change a parenting plan which is well thought out, which puts the right number of days with each parent, which gives the father a lot of weekend time.
My point is that your argument in support of the plan on this issue is not supported by the cases that you cite. In fact, they support the father's argument.
I respectfully disagree, Your Honor. What those cases say is
You're allowed to do that.
I appreciate that. Those cases say that the religious upbringing of the child is left to the legal custodian. In this case, there's joint legal custody. So it's up to those two parents together to decide what to do. Counsel made a point, I'm sorry.
But I'm sorry to interrupt, but it's impossible for the father to exercise his rights as legal custodian given the schedule the judge has set.
It's impossible for the father to take the children to Mass under the schedule. That is true.
So why isn't that a problem?
Because going to Mass is not the only thing that makes a person Catholic, and he does have the ability to take them at least one.
Well, it's a very important part of being Catholic, is it not?
It is. It is. It absolutely is. I don't disagree with that. But I don't disagree with that at all, Your Honor. You are absolutely right. Now, I'm wearing a cross, so I know that.
I noticed that. I wasn't going to raise it.
So I can't argue that, because it is a very important part. But the children being baptized, which is what made them Catholic, was a decision made by the joint legal custodians. Those two parents at that time.
It would seem then that the mother who's not religious wouldn't have an issue with the father taking them to Mass, and it's only the parenting plan that's preventing that from occurring.
The parenting plan doesn't actually prevent the father from taking to the Mass. It means that he doesn't have the children when Masses are normally offered.
Well,
that much is true.
That makes his argument too.
I can't argue with that, Your Honor. You're 100% right on that, except this is not something that this court should get into.
It's the only place I'm ever 100% right, never happens at home.
Well, we're looking at what the father is asking you to do is to change a parenting plan that's well thought out based on 99% of the evidence.
Is it really well thought out?
Well, it is. It is. But to change it for a religious reason. If there was a secular reason for changing it, that would be certainly within this court's province.
You're not saying he doesn't have any rights, religious rights, as a legal custodian, though. So why would it be inappropriate to change it for religious purposes?
Because it would be inappropriate because this court should not impose a religious purpose on any judgment of any court beneath it.
See, and that is the argument you've made in your brief, but that's not what's occurring. Instead, what we have is a court preventing the father from letting his children practice the religion that they were baptized into. That's why the cases you rely on are inopposite.
See, but I again disagree, Your Honor. The court is not saying that these children cannot go to Mass. The court
Counsel,
is,
are you suggesting that it could be accomplished with the mother taking the children to Mass?
it could be, and I will agree, the record says that the mother had not in the past gone to Mass because the father was taking the children to Mass.
But we know from the record that she has not taken them to Mass ever, and probably has little incentive to do so since she herself is not Catholic.
You could definitely read that in what's in the evidence. I agree, Your Honor. If Your
sorry.
Honors will allow me to run on to
Yes,
another,
please.
another
Go
topic.
ahead.
Father also complains about the division of marital estate. But, of course, the division of marital estate does not have to be a 50-50 split. However, in this case, there was the land that was given to the family by the mother's parents. That was worth $260,000 at the time it was given. The property as it existed at the time of divorce was worth $850,000, so a $590,000 appreciation. What Judge Simons did was he looked at that difference, and another fact that I'm going to mention in a minute, and he said, I'm going to make the mother's going to get the property, because that was the land that she grew up on, was the land that her parents gave her, but I'm going to make her pay $250,000 to the defendant.
The father had put $3.5 million into the property, correct?
If the father did in fact put $3.5 million up, and I think it's 3.2, he put it into the property to appreciate its value by only $590,000. So if he really put $3.3 million of marital assets in there, which I don't think he did, he wasted all that money. The most value he added was $590,000, but there's no finding as to how much of the appreciation of the house was due to natural appreciation of land over time and how much was with respect to the improvements that were made. In fact, there wasn't any evidence presented with respect to that. So Judge Simons was not inappropriate in awarding back to the father 42% of the appreciated value, which is what the $250,000 over $590,000 comes out to be. But also, there's another finding in there. There's a finding that Judge Simons made that the husband took $660,000 of the marital estate, $660,000 from his bank account, and gave it to his parents on the eve of the divorce action being filed, in December of 2019. So if nothing else, the wife's entitled to a credit of $330,000 for that. So when you look at that and you put it in context, the division of the assets was not improper, not at all. The other thing the husband complains about with the division of assets was that mother got to keep all of her $50,000 Massachusetts state teacher's retirement plan, where all he got was $5.5 million in a trust of which he's the sole beneficiary. I don't understand the argument that the marital estate was not distributed properly. With respect to the child support, what Judge Simons did is he took $48,000 that the husband was receiving from his father's company at the time of trial, for which the husband, by the way, testified that he did no work, and he added $52,000 that he found the husband could have acquired in income per year from his photography business, because the husband testified he could make $100,000 or more, and he had done that in Berkshire County for 4 years prior to getting married before he voluntarily walked away from it. I think the judge could, well, and the other thing I should mention, what the husband was getting from his father's company for doing no work was $100,000 at the time the divorce started, $100,000 a year. But when it came time that mother filed a motion to get child support, temporary child support, father's father all of a sudden cut his salary by more than half, from $100,000 to $48,000. So I think Judge Simons could have been justified in finding $200,000 worth of income per year. Certainly his finding of $100,000 per year is within the realm. The guidelines in the cases don't say that you can't add attributed income to actual income when they're not mutually exclusive. Both the cases that my brother counsel has mentioned are in cases where they are mutually exclusive. What the judge is required to do is attribute to what the husband can reasonably earn with a reasonable effort.
We're going to have to leave it there. Thank you.
Thank you, Your Honor.
Thank you, Bull. The next case is 22P801 John Doe 5976 versus the Sex Offender Registry Board. Mr. Burkholder. We set the time?
May I proceed? Good morning, Your Honor. Fred Burkholder on behalf of John Doe 5976. I hope I didn't lose any of my time. I
No,
didn't know
you're
when I
good.
was supposed to start. Usually there's an introduction. That said, judges, I should say, in this case, I think both of the briefs set forth in sufficient detail the facts, so I'm not going to belabor the points. Basically, what we have here is an allegation of new conduct, which certainly would warrant a basis for reclassification. My contention, as set forth in the brief, in summary, is that it wasn't sufficiently detailed, it wasn't plausible, and there wasn't sufficient corroboration for it to form the basis of evidence which a reasonable person is accustomed to rely upon in the conduct of affairs. Now, why do I say that? I spelled it out in the brief, but I'll try to highlight the main factors. First of all, if the offense occurs to the young lady, why doesn't she tell her mom? Why does she tell her own counselor, who indicates that she has a good relationship
Why don't we
with her?
focus on who she did tell?
Well, that's not necessarily clear from what's in the record, but I will address it as my understanding.
Well, there was a SANE interview, so she...
Well, to start with, I mean, if chronologically, supposedly she texted her boyfriend.
Right.
And then supposedly she told her boyfriend, but nobody could indicate when that occurred. And then text
But we
messages.
have the texts in the record, though.
No, we don't.
There's no record of the text?
There's no record of the text, and there's no record of the Facebook messages either. That's where it gets a little fuzzy, if I may try to explain what my understanding is. So allegedly the events occur. When she tells the boyfriend of what, we don't know, because neither person says it. When she texts the boyfriend, we don't know. Then at some point, the boyfriend, not the victim, not the victim's mother, talks to his counselor at school and says, my girlfriend says this is what he's doing. Doesn't specifically set forth in detail what he's doing, speaks in very general terms and speaks in very general time frames. As a result, then the young lady, a DCF report is made because there's a mandatory referral, and there's a SANE interview.
The boyfriend,
that's conducted.
we'll call Kay, he did show messages to the counselor.
Supposedly, but there's no references to what exactly they say, and the counselor doesn't say, in the record that I read, doesn't say, yes, I saw those. Doesn't say it, because I would submit in a minute, then I'm barking up a wrong tree. Those messages then don't exist. Then the Facebook supposed site, I don't know what you want to call it, but that particular site, he couldn't access, so there's no way to determine what those were as well. So we have no corroboration. His corroboration is limited to, yeah, something happened, I'm not certain when, maybe I had some messages, I don't have them now, and I don't have an excuse why I don't have them.
Well, he said his phone broke, right? He did tell the guidance counselor.
He did tell the guidance
The guidance
counselor.
counselor speak to the victim?
No, yes. Guidance counselors together spoke to the victim.
She's a mandated reporter.
Right, and she refers it to SANE, and SANE does investigation, and the first thing that's asked of the daughter or of the young lady is, what happened? And she pauses and says, can we come back to that? That's why she's there. Then she details a couple events. In detail, she says, not what she says, but what she doesn't say is, okay, something happened right after Thanksgiving in 2018. Another thing happened on one occasion. Doesn't say when, where, how, whatever. Third thing, when I was in the 8th grade. Any other specific times when asked to remove her shirt, grab her, and slap her, were unable to provide any details. Here's what my thoughts are, Judge. If you look at the interview that was conducted by DCF of the mother, found at Exhibit File 4, pages 10 through 13. Specifically on page 10, there's a paragraph that talks about the relationship that is in existence between the daughter and the boyfriend and the issues that are going on with regards to the father. It's concerning that that would be in existence. Mother is concerned if there's something that would have happened, why didn't she tell me? I've observed them together, and how he relates to her is inconsistent completely with what occurred. There's also lack, of course, of any documentation from any medical provider of anything that occurred. So, I mean...
Well, I mean, what sort of medical verification would you have with an indecent assault and battery, Mr. Burkholder?
Well, maybe you wouldn't, but maybe that's important as well, because then it indicates that at worst, what do we have here? We have possibly an improper touching. If you look at and I'm not condoning that.
It says in the same interview that there were multiple touchings over multiple days, and it was really quite detailed, and the detective was there for the same interview, so that's not triple hearsay, as you call it.
The detective was in the other room.
Yeah, that's how a sane interview works.
Okay, okay.
It's supposed to be less traumatic for the
we're
victim.
We're entitled to a difference of opinion. I just don't think that they're detailed.
But we're not entitled to a difference of the facts.
If this individual is on a witness stand in a criminal trial, and I know that's not the standard because it's preponderance of the evidence versus beyond a reasonable doubt, but if this witness was on a witness stand and I or some other criminal defense attorney had the opportunity to try to pin her down with respect to when these happened, why it didn't happen, why she didn't tell or otherwise, it certainly would at least suggest some degree of doubt.
Well, you just seem to suggest that a conviction would be necessary for a reclassification.
I'm not suggesting that at all. I'm suggesting that in cases, you know, it's funny. I sat and listened to the last argument. I spent 20 years doing domestic relations work. So part of that, of course, involved custody litigation where people would come forward and say things about this person and that person and the like. This just strikes me as the type of situation where that similarly occurred, because there was concern of the mother, because she shared it with DCF that there's a problem between the boyfriend or otherwise, because the boyfriend brings it forth, and then the young lady doesn't want to say it.
Aren't those credibility determinations for the hearing examiner?
The other courts at this level have reversed decisions when they found there's not substantial evidence based upon credibility.
You seem to be making an argument that she shouldn't be believed because she didn't tell her mother.
Well, no, Judge, the factors are in aggregate. You look at plausibility. That's the argument with regards to the brother, or the boyfriend. You look at corroboration. That's the argument with regards to the lack of detail. Here's, I guess, the question that I would say with regards to the boyfriend. If the boyfriend can corroborate her testimony, which seems to be important by the case law, then why didn't he detail what specifically the young lady later told in the same interview? Why didn't he say, this is what happened, this is what happened, this is what happened?
And concerning enough for him to go to the guidance counselor and report.
Unless he had a motivation to try to get the man out of the house.
Again, credibility determinations are for the hearing examiner.
Okay. All right. I disagree, but nonetheless. May I go on?
Yes.
All right, so then we come to the next argument. The next argument is, what do we do with the information, assuming that we find that that credibility determination was sufficient, all right? Now we have a question of what level should this individual be placed at. Again, I mentioned before, DOE 49601, 496501, says we should look at these offenses and offenders on a continuum. Over here, of course, we have someone who's gross sexual or serious rape and the like. Over here, we have, you know, the exposure offenses. Somewhere in between is where this individual falls. There's no penetration, there's no violence, there's no injury or otherwise. The offenses are 20 years apart. and the like. This is not a level 3 case at first blush to me. And I've had Superior Court judges look to me and say, there's no penetration, Fred, there's no violence, there's no whatever. Why is this a level 2 case?
Is there a case that says that a level 3 classification requires
No,
penetration?
of course there's not. Of course it's not. It's all a judgment evaluation. And that's, those of us that practice on this side of the fence in these cases, that's the problem that we have, is we're asking this court to make a determination with regard to the balancing that occurred. In at least one case and one panel that I indicated in my brief, I think it's Doe 32579, the panel looked and said there wasn't a sufficient explanation of what in fact occurred. I reread the explanation sitting waiting for my turn to argue, and it couldn't be any more scant than possible. What's the difference between 2005 and present? These allegations, again, it's contact offense, but it's nothing in comparison to an aggravated rape or otherwise. One probation violation that occurred 8 or 9 years ago, in 2013, and then one of criminal conduct with the police. That's the only thing that's changed. He's got a stable home, he's got a job, he's gotten a little older. I think that it's one of these cases where the judge looked at the nature of the offense and said, because he's had 2, he should be a level 3. If we said that about every individual that has 2, everybody would be 3s. How many people do we get before this court that
There's
have
more
isolated
aggravating
offense?
factors than there were 2 in play here, and you know that.
Not to any great degree, Judge. We have repetitive and compulsive applicable if we credit that. Other than that, we have an adult child.
Offender, child victim, extrafamiliar relationship, violence unrelated to sexual assaults, moderate weight, noncompliance with the community supervision, number of victims, repetitive and compulsive behavior.
Okay. The violation occurred
First
in
victim was
2013.
prepubescent.
Violation occurred in 2013. The assault occurred in 2012. This is dated conduct. It's dated conduct. It's not what's happening today or yesterday.
Is that a matter of weight for the hearing examiner?
It is, but it's also a matter of a hearing examiner having the responsibility of explaining how they balance these things and coming up with a determination. My argument, as stated in my brief, and I'll rest with this, is that that explanation wasn't sufficient. Unless there's any questions?
Seeing none, thank you.
Thank you.
Ms. Blackman.
Good morning. May it please the court, Jessica Blackman on behalf of the board. Just by way of brief history regarding the sex offenses, not necessarily the details of them, in 1997, at the age of 20, Doe sexually assaulted an 11-year-old prepubescent girl who lived in his apartment building and subsequently pled guilty to the enumerated sex offense of indecent assault and battery in 1998. Undeterred by these sex offense convictions, in 2018, now at the age of 41, Doe was again investigated by police for allegations that he had sexually assaulted his girlfriend's 15-year-old daughter on multiple occasions and was arraigned on 3 counts, 1 including rape, indecent assault and battery on a person over 14, and enticement, of which he was later convicted of the indecent assault and battery charge. It was these 3 pending charges at the time that prompted the board to evaluate Doe's current risk to reoffend and degree of dangerousness in 2021, and ultimately find that he be reclassified from a 2 to a 3. With regard to consideration of the hearsay evidence, Doe's argument is there was an abuse of discretion in admitting and crediting hearsay statements contained within the police reports and the DCF records. Just to go to my brother's argument with regards to the text messages that you had discussed, you can look in the police reports, which 4th paragraph on page 43 of Exhibit 1, you can see where the police indicate, in the Fall River Police Department, indicate that the boyfriend produced text messages from the victim implicating what had occurred. And then if you go to the DCF records, which which are in Exhibit 3, page 167, you'll see that following the mandated reporter and the 51A being filed, DCF indicated that the guidance counselor will forward copies of the text to DCF that she had in her possession from the boyfriend. First and foremost, it's well established that a hearing examiner is not bound by the rules of evidence and may admit and give probative effect to the evidence that is the kind of evidence which a reasonable person is accustomed to rely upon in the conduct of serious affairs. With regard to Doe's argument that the information contained in the Fall River police reports, authored by Detective Pereira and pertaining to the allegations of abuse by Doe, was inadmissible because the officer did not personally interview the victim. I think Your Honor stated pretty clearly that is because there was a child involved in this case, that is how SANE interviews are conducted. The detective was in a room next to the SANE interview taking place and watched it through video. That video and the audio were also recorded and provided as evidence as part of the detective's report. Not only was Officer Pereira's report and the information within it obtained directly from the victim during the SANE interview, but this procedure is common in crimes involving children. As to the statements obtained from the third parties, specifically the boyfriend and the guidance counselor, Doe is correct insofar as categorizing them as non-eyewitnesses, but this does not render the statements unreliable or inadmissible. The information provided by the victim's boyfriend and subsequently to the guidance counselor, who is a mandated reporter and required to file the 51A report pertaining to the allegations of sexual abuse, was originally obtained directly from the victim herself, either verbally or in the form of text messages and emails, which were subsequently forwarded to DCF and the police. More importantly, these third-party statements and the relevant information contained therein were in fact corroborated through the investigative interviews and statements provided directly from the victim during the SANE interview, substantiating, this led to DCF substantiating the sexual abuse claims and making a referral to the DA's office.
He does say that the hearing examiner fails to mention anything that he hadn't committed any offenses between 2012 and 2018. What do you say to that?
I think that fact is irrelevant in this case. The only factor that would be relevant to that would be offense-free time in the community. But as soon as he was convicted and or investigated and convicted of a subsequent sex offense, basically deems that period of time irrelevant because now we have a charge for a new sex offense. So offense-free time in the community basically disappears upon a finding that that subsequent sex abuse occurred and did not prompt the hearing examiner to apply that factor in this case.
Does the record reflect what happened to the 2018 charges?
He was convicted of the indecent assault and battery. So in finding that the hearsay statements were credible and reliable, substantial evidence was therefore present to support the hearing examiner's findings that both a high risk and a high degree of danger in support of the level 3. It was clear and in line with the Superior Court findings that the hearing examiner did not merely list the board's factors. He provided a detailed account of the evidence considered and an explanation of the relevant weight assigned to each factor pursuant to Doe 23656, and in turn sufficiently satisfied the burden, lending to a decision that was supported by sufficient evidence, was not arbitrary or capricious, an abuse of discretion, or based on errors of law. His findings were reasonable and entitled to deference. Unless the court has any other questions specific to either the substantial evidence issue or the hearsay evidence, I will rest on my brief.
Seeing none. Thank you. Thank you both.
Thank you.
We don't do rebuttal, Mr. Burkholder. The next case is 23P258, Karen McNutt versus the City of Boston Zoning Board of Appeals. Ms. McNutt.
Good morning, Your Honors. My name is Karen McNutt. I am the attorney, and unfortunately, I'm also the plaintiff, and that's a position a lawyer should never put themselves in. But I found myself in sort of a box. And I'm going to apologize because my lawyer, part of me wants to use the term plaintiff and defendant, and the personal part wants to say I. And I just can't keep them separated, so I apologize for that also to the court. This is an appeal of a summary judgment case in the Superior Court involving zoning issues. Because it is a summary judgment case, it reaches this court a de novo, giving no weight to the Superior Court decision. It's a zoning case out of the City of Boston. The issue is standing. There were cross motions in the Superior Court. The plaintiff was saying that there was no grounds to issue a variance because the defendant could not meet the 7A requirements for a zoning variance. That is, their lot had nothing particular about it or unusual about it that made it difficult for them to use the lot. Their lot is identical to almost every other lot on the street. Defendant said that plaintiff didn't have standing and therefore couldn't reach the substantive issues. The court found for the defendant saying plaintiff didn't have standing, and that brings us here. The houses involved are two-family houses in an area zoned for two-family houses. They're all on undersized lots because they all predated zoning, so they're all pre-existing non-conforming uses. I think it's in I did a survey of the assessing records, and it will show that something like out of 100 and some odd lots, 90 some odd are on undersized lots, a big number of undersized lots in the area. The houses should have 43 feet of frontage, which we have. They're supposed to have 5,000 square feet of area, but we both have 4,600 and change, so we're undersized. The defendant wanted 6 different exemptions from zoning, including lot size. He wanted to go to a 3-family from a 2-family to build out his attic into a full floor for a 3rd family, and to place a very large addition out in his backyard that basically expanded the footprint of the house, running it all the way to within 18 feet of the property line in the back.
But you're not the neighbor, but you're within 300 feet, so you have
I'm within 43 feet, yes, Your Honor. So I'm in a butter to an abutter within 300 feet.
You have a presumption of being an aggrieved party.
That is correct, Your Honor.
But the court found that you didn't meet your burden for standing.
That's correct, Your Honor.
Do you want to address that?
Sure. My primary basis for standing was based on the case of Shepard versus the Board of Appeals of Boston. That's a case out of this court. And in Shepard, Shepard was an East Boston case, I believe, in which the defendant bought a piece of property, had a dilapidated house, tore it down, put up a new house, but the new house was going to be bigger. And Shepard objected based on the fact that she was going to be deprived of light, decreased rental value, increased risk of fire, decrease of privacy, increase of noise, all of which the Superior Court judge says, nah, I don't find that. That's insubstantial. You have no standing, just like me. When she appealed to this court went through all of the standards required to show that zoning relief was adversely affected her, that the injury was really to a cognizable interest protected by zoning, that her concerns were special and different from the rest of the community. But the court noted that zoning review of standing does not require the finder of fact to ultimately find a plaintiff's allegations meritorious. Now, I'm getting to your point, so please bear with me. The court found that an abutter has a well-recognized legal interest in preventing further construction in a district in which existing development is already more dense than the applicable zoning regulations allow. And then it went on to say that the injury to Shepherd was related to density, and density is an interest protected by the zoning laws. It then went on further to say, and I'll read it, the requirements regarding lot size, lot width, and side yard interests further these purposes. So these are all relating to density, as quite frankly would increasing from a two-family to a three-family and putting another structure on the property. That's all density issues.
But the SJC has said that you have to allege more than a violation of a zoning law or bylaw.
I will get to that, okay?
Well, it'd make me happy if you got to it now.
I'll get to it right now, okay. That's in the Murchison case, I believe.
Yes.
Murchison case cites Shepherd and exempts it, basically. This is not a Shepherd case. And that was part of my argument, but I'll say it right now. And there is a specific thing that Shepherd is not included within the Murchison decision for a couple of reasons. One, in Murchison, there was no indication that the density requirement, that the zoning requirement affected density. It was a case in which I think there was a 3-acre lot with 250 feet of frontage, and the claim was at one place the lot was a little too narrow to build a building, but everything else was okay in zoning. And the court says, no, just because it's a little too narrow one spot, that doesn't mean that there's a density problem.
It has to be more specific. It can't be generalized. You have to show that.
I'm sorry?
It has to be more specific. You can't just have a generalized concern about density. You have to illustrate how you were harmed.
Let me quote from Shepherd, which has never been overruled.
I want you to answer my question. How were you harmed?
I was harmed because the further development in a zoning area that is already overdeveloped under the zoning laws creates a, quote the case, a sufficiently perceptible and personal interest to qualify the abutter as aggrieved and thereby confers standing.
That's a generalized interest in why anyone would be against density. The cases say, Doyle in particular, are the land court. They cited it, and they said that you have to show some specific harm to you personally.
The harm to you, and again, quoting Shepherd, is the fact of the increase in density in an area that's already overdense. Shepherd has never been overruled. There's all the cases exempt the areas where there's already been overdevelopment. There is no case, I looked at them all, there's no case that you can point to that says in an area where there's already been overdevelopment that there's a need to show more on the case of an abutter that's complaining. Now, because I read the same case as you did, I tried to cover my bases by bringing up 3 other problems. One was loss of light, loss of view, and I'm not talking about an aesthetic view. I'm talking about the fact that if he builds on that property the way he wants to build a 3-story building that will pretty much cover the lot, that there is a loss of a view of the sky because the building will take up so much space, and also it then puts my backyard into what in fact is a hole.
Did you supply evidence of how it would affect?
I did.
In what fashion?
Photographs, Your Honor, and an affidavit. And that was referred to as my light study. And I give you a cite to that, but I'm a little outside my notes. It's in the
Volume 5 at 253,
yeah, thank you, Your Honor.
252.
How did the judge comment on your light study?
I'm sorry, I can't hear you.
Did the judge comment on your light study? How did the judge?
No, the judge repeatedly, in her opinion, would say, that's simply opinion, there needs to be an expert, that's speculation. Well, first of all, any building that hasn't been constructed, anything dealing with that is speculation to a certain point. But the standard is it likely to occur? They put the building up, it's likely to block. Secondly, there is no requirement for everything to be backed up by an expert. And there's a case on that. There's a number of cases on it, but...
But there was an expert study from the other side.
Yes.
Did the judge rely on that?
Yes, she did, but I objected to it. I objected to it.
And there was no ruling as to that?
I'm sorry?
There was no ruling?
There was no ruling. And my brother indicated, and I agree, by not ruling on it, she has implicitly denied my request for a motion in limine to not have that study considered. There was...
Speak to why she was wrong.
The reason she was wrong is the study, for one thing, does not meet Rule 56E, requirements for affidavits. The person who signed the affidavit explaining the study was the office manager, and he's interpreting something which appears to be a scientific study, that is how light strikes a piece of property during different times of the year. That would then call into question your Lanigan and DeWitt questions on, is the study valid? Is it accepted by scientific evidence? Is it accepted generally accepted in the field? None of that was put before it. The person who supposedly did the study didn't prepare an affidavit that said, I prepared this study, I did it according to the rules, the study's accepted, yada, yada. None of that was there. It was just office manager, and here's a whole bunch of pictures of diagrams. And if you look at the diagrams, they say no scale. How can you have something with no scale and have it be, acceptable? So it did not meet the 56E rule that required it be on personal knowledge, and that anything that is supplied with the affidavit be certified or attested to in some fashion. So it did not meet that standard.
With respect to the fire hazard issue,
That's correct.
I understand that you presented some evidence regarding fire. It wasn't the evidence to the effect that sort of any additional structure or any structure that allows additional people would inevitably lead to additional concerns for fire safety?
To a certain extent, but the specific problem is because the addition would extend out into the backyard, it would create what's called a fire face, a direct line between my back porches and the new structure. And should that structure catch fire, it's within the zone, within the area that an ember could jump, or that spontaneous combustion, that is the heat of the fire, could cause the fire to jump to my house. Without the addition, there is a house between my house and a defendant's house that would be a buffer in case of a fire in defendant's house. Now, with that extension out in the backyard, there's no buffer. There's a direct line between my house and the new extension. And Mr. Marlowe, who was the 35 years in the fire department, 13 years as a fire inspector, said there was a strong likelihood that if there were a fire in the extension, it would jump to my property. And then he said it was highly possible that there would be a jump of fire from the extension to my property. And quite frankly, it's very common where the houses are all so close together in the neighborhood, and they're all 100 years old for the most part. They're all wood for the most part. Fire is a big problem. And a real concern. And so that was what he said out there, and the defendant had nothing to rebut that. There was concerns that actually go to the street overcrowding would make it more difficult for fire vehicles to get in because of the parking and the street congestion. And there were a number of other issues discussed in his deposition. I think that puts me over.
You have a minute.
I have a minute. Okay. Let me just say this, Your Honor. There's no oversight of the Zoning Board of Appeals. And if the gate is held too close that people can't get through to complain about what they do, then you open a possibility of corruption, and there's no other way to put it. Every agency should have some oversight. Zoning Board of Appeals has none, and that's not right. And I think that on that basis alone, this court should be, as the case law says, should not be too strict in interpreting the question of standing, the gate through which people who want to complain have to pass through. There is no doubt in my mind that the defendant would not meet the zoning requirements for a variance if the substantive issues were raised. And so now we have a question of why isn't the Zoning Board of Appeals doing their job? And I want to thank you very much for your patience and understanding.
Thank you.
Thank you.
Mr. Nabulsi.
May it please the court, my name is Samuel Nabulsi for the appellee Diana Avalone, the homeowner of the property at 135-137 Minot Street. I just want to start by saying that I completely disagree that there is no oversight of the City of Boston Zoning Board. That oversight happened in this case. It's the Superior Court that provides oversight of the Boston Zoning Board of Appeal.
Don't leave us out.
I was getting there, Your Honor. On the question of there being no gate for people to complain about projects, that's also incorrect. There's voluminous case law from this court and from the Supreme Judicial Court on what it is required to pass through that gate in order to challenge decisions of the Boston Zoning Board of Appeal. And those decisions require, not only do they put the burden of proof on the challengers to demonstrate that they have standing, but at that juncture, they require that that standing be supported by credible evidence, which is not the case here. This court should affirm the decision of the Superior Court for 3 reasons. First, Attorney McNutt did not put forth credible evidence demonstrating that her interest protected under the Zoning Act would be harmed. Second, 2 of those interests, the access to views of the sky and concerns over fire safety, are not interest protected by the Dorchester Neighborhood Zoning District Code. And third, the allegations about overcrowding that rely solely on violations of dimensional regulations is insufficient to have standing.
Well, you call it dimensional, but this is we're talking about a 2-family to a 3-family. That's part of the claim as well, right? That's not dimensional.
That's right, Your Honor, but what Murchison says is that pointing solely to the language of a bylaw or an ordinance or a code alone, without demonstrating some particularized harm that arises from those violations, particularized to you and not general to the neighborhood, without that alone does not confer standing. And in fact, before Murchison, that was the case law of this court. In our brief, we cite to a case of Murrow v. Emery. I'll concede that it's a Rule 128 decision. I know it's not binding on this court, but it's instructive because in that case, it actually addressed the argument that Attorney McNutt raises head on. It dealt with an overcrowded neighborhood. It dealt with an urban environment. And what it said is, it's still not enough to point to a code. The plaintiff has to point to, again, some particularized injury that arises from those violations of whether it be a setback requirement or a frontage requirement or a height.
Shepard, then.
What's that, Your Honor?
How do you read Shepard?
I read Shepard as very consistent with that. First of all, I'll say that Murchison was decided several years after Shepard. And I think, going back to the procedural history of Murchison went differently in this court. When it got up to the Supreme Judicial Court, that decision was flipped and the Superior Court judgment was affirmed, and the point being that you cannot just point to violations of zoning ordinances alone to have standing. In addition to that, in Shepard, it's not true that the plaintiff in Shepard just pointed to violations of the local zoning codes. In that case, the court went on to say that there is a particularized harm to this individual because the pointing to the violation of a dimensional regulation came with the fact that now 19 feet away from this person's home in their backyard, there was going to be a significant structure, and the court went on to say that that addition blocked the very last free corridor that was viewable from this person's property. There was a particularized harm in Shepherd.
That sounds like the same claim that's being made here.
No, Your Honor, it's not. In the overcrowding argument, the only point that is being raised is that there are violations of dimensional regulations. Now, in a different part of the Superior Court proceedings, Attorney McNutt argues that there's a reduction in access to view of the sky because of this construction. She relies on an affidavit prepared by her and not by any expert, which the court does talk about. The court points to that last sentence of her affidavit that says, I believe that the structure will block an access or view of the sky. The reason that does not work here is that in the Kenner decision that we cite to in our brief, views, whether it's view of the sky or view of a particular structure or view of something that is aesthetically pleasing to you, that's not a protected interest under the Boston Zoning Code unless it expressly identified as a protected interest under the Boston Zoning Code. There is no provision in Article 65 of the Boston Zoning Code that governs the Dorchester neighborhood that provides for the protection of views. Now, Ms. Avalani took it a step further. Remember, at the summary judgment stage, it is enough to say and argue and challenge the presumption by saying that the plaintiff does not have a reasonable expectation of putting forth credible evidence to demonstrate standing. But Ms. Avalani took it a step further. Not only did she point to the fact that Attorney McNutt was relying on a self-serving affidavit and not on any sort of expert analysis about shadows, impacts to available light, both ambient and natural, but Ms. Avaloni also produced her own light study. It was not prepared by an office manager. It was prepared by the principal of Roach Christopher Architecture LLC, James Christopher himself. He did prepare an affidavit addressing the sun study, the shadow study, and that shadow study was prepared by someone else. But we also cite, too, in our brief, the case law is very clear. When there is hearsay in an affidavit, it doesn't go to the admissibility or non-admissibility of the expert's testimony, it goes to its weight. It's not clear whether the Superior Court relied on the sun study, but Ms. Avaloni produced evidence that the project would not have any impact, certainly nothing more than de minimis, on Attorney McNutt's property. In fact, under that sun study, during most parts of the year, there would be no shadowing effect at all from the three-story addition to two properties down from Attorney McNutt's property. Only 2 times a year, at 3:00 p.m. in the afternoon, there would be a slight shadowing effect on the westernmost part of Attorney McNutt's backyard. That expert testimony, whether it was relied on by the Superior Court or not, just demonstrates that the affidavit that was submitted by Attorney McNutt and not by an expert does not really create a genuine issue. It's not really anything more than Attorney McNutt's personal opinion or beliefs about the harms that she will suffer. But this court and the SJC have been really clear. In order to meet that standard of producing credible evidence, one cannot rely on personal opinion, personal hypothesis, or personal conjecture.
Well, she submitted 2 photographs, correct?
Yes, Your Honor.
That's not conjecture, hypothesis. I mean, we can put ourselves in her backyard and see where the addition is going to be, correct?
Perhaps. The photograph doesn't actually show the addition. It shows a current view that she has and a belief that that view is blocked. But again, it doesn't matter whether this will block a view, because the ability to have a view is not a protected interest under these provisions of the Boston Zoning Code. It is a different story if
But it's more than the view. It's diminished light could be, diminished open space, diminished light could be a status, could give a person status as an aggrieved party.
It could,
and at the summary judgment stage, she's not required to prove by preponderance that her claim is true. She's just required to provide some sort of substantiation of her claim. And you're saying that the photographs of where the address, where the addition will be. She did a chalk or a drawing of what the addition may look like. You're saying that's insufficient even to confer her standing?
I do believe so, Your Honor, but also in the brief, there's actually no mention about the impacts to the light and availability of light on her property. In her brief, she actually only argues about the access to view of the sky. And even in the Superior Court, it was the same issue. When Ms. Avalone challenged the issue of whether the addition was going to have any sort of impact, it was in an abundance of caution that this was an argument that might later turn into a restriction on light or shadowing effects on the property. But those were actually never argued by Attorney McNutt. She's only focused on her ability to have a view of the sky and access to the sky, and that's not a protected interest under Article 65 of the Boston Zoning Code.
So we're reviewing the judge's decision. The judge did consider diminishment of light, open space, and air.
Yes, Your Honor, because we challenged that, again, in an abundance of caution. She did not, it's not clear from the decision whether Judge Connolly relied on our Sun study or not, because remember, we were challenging the presumption of standing as we were permissibly able to do so by arguing that Attorney McNutt was not able to put forth credible evidence that she had standing under the Boston Zoning Code. And so in Judge Connolly's decision, she focuses on the light study, which is this 2-page affidavit with a couple photographs that says at the very end, again, I believe that the property will have an impact on my access to the sky. It does not say anything. That affidavit says nothing about the impacts to light on the McNutt property. It says nothing about whether there will be a shadowing effect on the McNutt property. It says nothing about whether there will be an impact on light entering her property. It says nothing other than she will not have access to the sky. That's not a protected interest of under the Boston Zoning Code. You won't find anything in Article 65 applicable to the entire Dorchester neighborhood, let alone the two-family subdistrict, about access to the sky or views of the sky. The other point, Your Honors, that she brought up and relies on is this issue of fire spread and fire risk to the property. Again, we start from the place that not only do you have to put forth credible evidence, we did not get into the inquiry whether Mr. Marlowe, who is a neighbor and actually submitted an opposition letter during the zoning board proceedings, whether he is a qualified expert or not. But if you actually look at his testimony, which is in the record appendix, the first volume, pages 70 through 76, you'll see that even in his own words, the concern over fire risk and fire safety is highly speculative and conjectural. When asked whether there was anything inherently risky or flammable about the property, he said that there was nothing inherently flammable or risky about the property. When asked, well, what could cause a fire at 135, 137 Minot Street that could then spread 2 doors down to the McNutt property, he said it could be a number of things. It could be that there is oil on a rag in a bucket under the garage that combusts and causes a fire. It could be an automobile fire parked in one of the 3 off-street parking spaces in the back. It could be from shoddy electrical work in the mansard roof. All of these are situations that are highly speculative and are not really related to the zoning relief granted in this case. But then let's take his word for it. Let's say a fire were to start. We then asked him, how does a fire then spread to the McNutt property? And he gave us 3 different potential scenarios or factors that would need to be considered. Number 1, does the intervening property go on fire first? Remember, the McNutt property is two properties down. Does that house go on fire? Because that would then increase the risk that the McNutt property could go on fire. Second, the direction of the wind that day and how powerful the wind is that day. And then third, he says, how fast the Boston Fire Department responds. Too many things have to happen and fall in line for there to be a real risk of fire concern on the McNutt property from anything that happens at the Avalone property.
It sounds like this kind of folds into the general concerns with density and overdevelopment, sort of the primary argument here. Do you agree that this area is already overdeveloped according to the code?
I agree that in this area, you have a significant amount of lots that are undersized in comparison to what is required as the minimum lot size for the Dorchester neighborhood district. And you see that all over Boston. I do not know if that means it's overly developed or not overly developed, but it is true that you have lot sizes across this neighborhood that are smaller than what is provided by the Boston zoning code. But again, that is a concern that's general to the entire neighborhood. For that to be the thing that gives a person standing, it would fly in the face of all of the case law out of this court and the SJC that says, in order to have standing, your claim has to be particularized, special, and different from the concerns.
In an area that's already overdeveloped, you're saying not a single person in that area would have standing really to complain about the continuing variances that are issued to make a two-family neighborhood into a three-family neighborhood.
May I answer? I see my time is running out. They would have standing so long as they can demonstrate a particularized injury that results from that overdevelopment to them specifically.
Good. Thank you. Thank you both.
Thank you, Your Honors.
We're going to take a short break, and we'll return to hear the remaining cases.
All rise, please.
Our next case is 23P29, True Dynamics LLC versus Top Flight Technologies Incorporated. Mr. Needham.
Good morning, Your Honor. As an order of business, we have an appeal and a cross appeal. Do you want me and my 15 minutes to address both of those?
Yes, please.
And will there be a possibility of additional time if there's enough time?
There'll be no additional time.
Pardon me?
No additional time. You get 15 minutes.
All right. Let me proceed. I represent the appellants, cross appellees, and True Dynamic and James Plunkett. And we got a verdict in Middlesex Superior Court. We got contract damages, which we are not appealing. We did not recover under the wage claim. That's what we're proceeding on today. And to be a little more specific, it was a wage claim. It was denial of a motion of new trial based on the wage claim. And the wage claim is a really incredible piece of legislation. You get treble damages, you get attorney's fees, you get strict liability, and you get a burden shifting. And we had that burden shifting in this case because the jury found that my client performed services, that James Plunkett can perform services. That's the answer to special question number 13.
Also, could I ask you before you get into the merits, question of standing? The appellee raised standing. I don't believe you addressed it in your response brief, but there's a question of standing, whether or not this is a business-to-business agreement or an individual-to-business agreement. And
Well,
under the guidelines by the Attorney General, again, as set forth by the appellee in their brief, could you, again, address your client's standing?
Well, my client is James Plunkett. He is a sole proprietor. He does business as an LLC. He has no employees. He was hired to do some work. He was made a project manager in doing something. The special question that the jury answered was that James Plunkett had performed services. And I think that's as far as you need to go under the circumstances. And
It was True Dynamic and James Plunkett, and one could see James Plunkett as True Dynamic. I mean, he was True Dynamic, correct?
basically, there was nobody else. He had an occasional employee that he hired. But you're going to see in the exhibit at the record.
There are certain factors that the courts look to determine standard, whether it's business to business or, again, an individual employee. And one is whether the alleged independent contractor's services were available to others. And you admit that's true, correct? You made lacrosse sticks, other things?
He made lacrosse sticks, he made other things, but this was something unique. This was something new for him. And you're going to hear that he signed on to do carbon fabrication for them. And he became a project manager. And part of our case is that he was required under the contract to build a prototype using updated 1.8K power plant capable of flight tests. And he did that. And the jury found that he did not breach the agreement. He did that, and that was all done individually. So I think that this is a unique case because this is not, and there's a lot of controversy in there about did he want to be an employee, did he not want to be an employee? And I think you're going to see in here that at page...
Well, when you say a lot of controversy, there was evidence both ways, but it's really not, that was the jury's arena, correct?
The jury made the determination that he was not an employee. And the argument that we make is once you perform the services and the burden shifting occurs, the defendant must prove all three prongs of the ABC test. And the second prong is that the service is performed outside. The defendant has the burden of proving that. The service is performed outside the usual course of business, which of course is impossible. The business in the testimony was to break hybrid drones, and this is what he was supposed to do, and this is what the company did. It was right at the heart of the company. They
What
made
about
him a project
Mr.
manager.
Needham, what about the contract itself? Paragraph 10.3 says that the parties here agree that they're independent contractors, and nothing in here creates an employment relationship.
Well, you heard Mr. Plunkett testify that They told him, you'll never be an employee, everybody's got to be 1099 until we get some substantial money in. And that, no, it took him 6 months to negotiate this contract. And when he got it signed in July or June of 2015, it was made retroactive to September. And he testified in the record, volume 2, page 100 and 101, that they kept putting it back in the contract that he was an employee. And he was saying, you got to take that out because you told me I can't be an employee. And it took him months and months and months. And they kept putting it in and said, well, the contract isn't complete. We'll have to take that out. And this went back and forth and back and forth and back and forth. And it does state that, but I think it's pretty clear in the wage claim cases that it's precisely the person who's going to misclassify you who makes you sign an agreement that you are not an employee and never wanted to be an employee, never will be an employee.
Well, wasn't it incumbent upon him at the time that the contract was signed to not agree to this language?
Well, there was no other, there was no deal. You couldn't be an employee. James Polo testified, and that's in volume 3 of the appendix, his testimony, 140, 141. No employees. You can't be an employee. You'll never be an employee unless and that's volume 3 of the appendix, pages 140 to 141. He was told over and over again, you can't be employees. And I'm reading from some of that. Did you ever tell Mr. Plunkett that under no circumstances would you put in the contract he was an employee? And he answers, that's standard in all our agreements. I would not have. So he had no choice. And he wasn't getting paid, and in the final analysis, he didn't get paid, despite the fact that they had tremendous success with this drone. They got all kinds of patents, they raised all kinds of money, and he didn't have a contract, and he spent 6 months negotiating it, and they said, that's not negotiable. You can't be an employee under any circumstances. You sign this, or you get nothing. And his testimony, I think, was pretty extensive on that. And that's part of what happens, and that agreement is signed by him. The agreement does mention True Dynamics, but True Dynamics was nobody else but James Plunkett. And then there's issues that have been raised about the numbers. How did the jury get to the number? Because you had 2 ways he could recover. When there was an invoicing event, if they raised more than $1 million in Series A funding, and they raised $5.3 million, time to get paid, and he has a choice. The choice is either cash or stock. And when the Series A financing was taking place, True Dynamic had to tell potential investors about any liabilities they had. And they stated very clearly in the documents that they had a contingent liability in this services agreement for 50,399 shares. And then when Mr. Polo was on the stand, his testimony was that this was $10 a share. So that comes out to $503,000. And if you take the 5% interest for about a year, and this is about a year from September of 14 to November of 15, you come out with about $529,000, which is exactly what the jury awarded. And now there's an issue that's been raised that, well, that isn't exactly what Mr. Polo said. Well, if you look in the record, and it's volume 4, and it's basically pages 55 and 56, he was asked about this exactly, and he's the chief financial guy. And he says, I don't remember. And then his memory is refreshed. And when it's refreshed, he asked if he's seen the part where it's going to be $10 a share. And then he said, well, you got to show me a piece of paper. I don't remember. He's shown the paper, which was a unanimous consent of the shareholders. And in that case, he said, yes, I do. And that was part of the closing, and that's your signature, yes. The other side has said that's not good enough. And I couldn't disagree more. The jury's perfectly free to draw an inference from that. That somebody gets up there who's a difficult witness. Oh, I don't remember. You got to show me something. Oh, do you have that piece of paper? Well, maybe. And sees it, and he never said, wait a minute, hold on. That's not so. That's not true. And I think that's the classic adoptive kind of admission where a guy who's fighting you on every point is shown this. There's already been testimony about the 50,399 shares. And it talks about $10 a share. And you show it to him, and he says, yes, that's correct. That is correct. And at that point, I think the jury is entitled to draw that inference. In fact, I don't see what else they could, because this is a classic.
Well, he's asked if he sees what's highlighted. He's not asked if his memory is refreshed, if he remembers the share price was 10.
But it says where I don't.
Follow-up question would have been, now is your memory refreshed? You remember the price was 10.
I think that under these circumstances, that's as far as you need to go because of the inference they can draw. You can always go better. You can always go for the home run. But this was enough because the jury to draw an inference that this man who looks at this document that says $10 a share, says, yes, that's my signature, never says, wait a second, that's not $10 a share, what are you trying to do? The same guy that said, well, I don't remember, you're going to have to show me something. Then he's shown it, and he says, that's correct. I think that's sufficient. I don't know whether the inference the jury could draw under those circumstances.
But the document he showed him was not introduced, correct?
Well, I tried to introduce it. It was part of 1,000 pages of closing documents, and there was a going around, and the judge would not let it in. And so it was established through testimony of Mr. Polo, who was the chief financial officer. And he said the 50,000 shares was already in by testimony. And then this came in by, and it's right there in testimony. Yeah, could I have asked a few more questions? Sure, you can always ask a few more questions. But I think this is sufficient to let the jury draw a very permissible inference under the circumstances. Now, Mr. Plunkett sought to be an employee for obvious reasons. And as I was saying about the statute, the legislative intent is strongly in favor of employees or misclassification. And it's strict liability. You don't have to be negligent. You get treble damages. You get attorney's fees. You get individual liability if the person is somebody like Mr. Polo. And you get the burden shifting. So the burden shifted in this case. And the second of the two prongs, the services performed outside the usual course of the business. It was right at the heart of the business. And I don't think there's any realistic disagreements about standing under the circumstances, since this is a Mr. Plunkett individually doing absolutely everything. It's not as if he came in the True Dynamics truck and said, I'll have to check with the people back there, and it's a kind of borrowed employee thing. He was the guy, and his name appears, and in the work order they put True Dynamics / James Plunkett, and in the receipt and acceptance, which they signed, because we had to go to a lawsuit where they said this stuff wasn't any good, and we had a receipt and acceptance signed by them saying everything was fine. In the receipt and acceptance, it talks about the services agreement with James Plunkett, and that's at volume 1, page 77 of the record. So I think under those circumstances, when the substantial funding came along, there was also testimony that those people then were made, some of the consultants were then made employees at that particular time. So we have a new trial, a motion for a new trial. And interestingly enough, in this case, until the jury came in and said that Plunkett had not breached the contract, I think that this argument didn't arise for us. Well, if he didn't breach the contract, he had to have done work, and very successfully, at the core business. So that was out. So our position is that that's the miscarriage of justice, the obvious question on a motion for a new trial. And the other side said in their brief that motions for a new trial are granted as rarely as a snowstorm in mid-May. I think it's more like a snowstorm in mid-March. They're very sparse about them, no question about that. But think about it. The legislature passes this Wage Claim Act with all kinds of teeth in it. Because usually when you're getting treble damages and individual liability, you got to have some showing of wrongdoing or wrongful misconduct. There's none of that here. And that shows exactly what they wanted to do. And you have a case I can't imagine being more on point with the core business. He was the guy that saved them, that came up with this drone. They got it patented, did a great job on it.
Okay.
And once they do that,
Mr. Needham, your time is up. Thank you.
why,
We'll leave the rest to your brief.
all right, I'd ask you to rule in Mr. Plunkett's favor. Thank you.
Mr. Turner.
Thank you. May it please the court. I'll start with the Wage Act appeal. And the standard of review, I would submit, is almost impossible for the plaintiff to overcome here. The standard of review is not a mid-March snowstorm. This court said a mid-May snowstorm. And you have to show, the plaintiff would have to show here that the trial court judge abused his discretion by finding that there was enough evidence to conclude that the jury did not act out of bias or prejudice. And there's plenty of evidence here to support that, the trial judge's decision here. First of all, there was a split decision where the jury awarded $500,000 to the plaintiff on the contract claim, which would dispel any notion that there's some sort of bias or prejudice on the part of the jury. There's ample evidence from witnesses that Mr. Plunkett and True Dynamic were hired as a vendor to provide carbon fiber fabrication services, that he had an employee, that he had his own shop, that he had his own equipment, and that the True Top Flight didn't have any of the necessary equipment to perform those services. Then you look at the service agreement, and it says explicitly that he's an employee, not an independent contractor. Now, I get the argument that sometimes you have to go beyond those agreements because an employer is going to want to hide that, the employment relationship. But in this case, you have the putative employee is the one who made the changes. The evidence is not that Top Flight told them, oh, you can't be an employee. The evidence was instead that and there's a March email that's in the trial exhibits.
It's conflicting evidence. Mr. Plunkett testified that he was told he couldn't be an employee, correct?
Conflicting evidence, Your Honor, but there's an email from him saying, I want to change this agreement to ensure I'm not an employee because I don't want the taxes. And I want to ensure this is a corporation to corporation arrangement. Those are his words. And so the jury heard those words and heard possibly the conflicting testimony and resolved it. And so that's a classic jury question and is not grounds to grant a new trial. I would say that the argument, I think the central argument is that he's an employee because Work Order 2, he was hired to make a drone. That's the language of Work Order 2, and that's the business of Top Flight. Again, there's conflicting testimony on that. The testimony from the Top Flight employees was that he did not build a drone. He didn't know how to make the hybrid motor. He wasn't involved with the rotors or the engines or anything like that. He was hired instead just to provide carbon fiber fabrication services. So there's conflicting testimony on that, which precludes reversal of the trial court's decision not to grant a new trial. Unless the court has any other questions on the appeal, I'd like to turn to the cross appeal.
You would admit when he was initially retained, it was much more clearly a vendor relationship. It was for carbon panels, correct? And then the job description did evolve into a prototype, which would be maybe the entire frame.
I would describe it, Your Honor, as there was an evolution where he was more involved with the actual designing process and making sure that whatever carbon fiber parts he submitted would work with the drone. I think it involved a lot of test flights, and I think he was intimately involved. But the testimony from the Top Flight employees was that he was not the project manager on the actual drone construction project. That remained Mr. Fan, the CEO of Top Flight, and instead he was just still limited to his part of fabricating carbon fiber components and making sure it worked. I was trying to come up with a metaphor, and the best I came up with, I'm not always successful, but the best I came up with was a baker in a sandwich shop. Like you have a baker who has his own oven, he makes his own bread, he supplies to lots of restaurants, and then you have a sandwich shop who says, hey, give me all your bread, or worked with me almost exclusively and helped me design this. I want a specialty bread that's gonna hold up to my toppings. And the guy submits, he supplies the bread to the sandwich shop. He's not in the business of making sandwiches. He's still in the business of supplying bread. And the same is true here. He was not in the business of making drones. And in fact, the testimony was that he had never been in the business of making drones, and he'd never worked on drones before this project. So he was not in the business of making drones. He was just supplying parts that go into the drone. On the cross appeal, we're seeking a reduction, a remitter of the amount from the jury award on the contract claim from $529,000 to roughly $390,000, and it's based on the lack of evidence on the share value. The only theory that plaintiff has offered to get the award up to the $529,000 is that the jury must have awarded the value of the shares at the time. There was testimony from Mr. Polo that he remembered disclosing to investors at the time of the Series A funding in November 2015 that they had recorded as a contingent liability 50,399 shares to Mr. Plunkett. But there was no testimony at all about value. And we got into a little bit into that during the previous argument, but he failed to ask the final question that the justice brought up. He failed to ask the question, does this refresh your recollection that there was a $10 share value? So the only words that there was a $10 share value came from counsel, who said, looking at this inadmissible document, do you see here where it says a $10 share value? The witness says yes, but that is not evidence of a $10 share value. And without that, the jury could never have come up with a $500,000 verdict.
But preceding that, he was asked, and he said, I think so. I don't have it up now. I don't remember if you say so.
He says, if you don't remember, if you say so. And then counsel asks, well, I'm not asking, I'm asking what your memory is, basically. And he says, I don't remember. Then he tries to refresh, which he does, and says, do you see on the piece of paper where it says $10 share value? Yes, I do. And that's it. So the jury was no witness ever testified there was a $10 share value. There was no piece of paper in front of the jury that said a $10 share value. And beyond that, there was no evidence that the share in the hands of Mr. Plunkett was worth $10. Remember, this was a beginning stage venture capital company. There was no evidence that there was a market for these shares, that there was a willing buyer for any of these shares. So we'd submit the jury there was not enough evidence for the jury to find a $500,000 award without that share value.
You don't think there's a permissible inference? He's asking about the share value. Who asks if it's 10? He doesn't remember. Mr. Pohl. Is it Pohl?
It's Mr. Polo.
Polo, excuse me. And when he shows in the document, as counsel referred to, Mr. Polo doesn't say what's this or what's that. He looks at it knowingly. One could infer and says, yeah, that says $10. You don't think that's enough for the jury to infer that, again, it looks like the share was $10?
I don't think the jury can make a reasonable inference based on a witness identifying a number on an inadmissible document. I really don't think that's a permissible basis. If he had remembered $10, or he'd remembered, oh yeah, I remember something, maybe something in the $525 range, something like that, maybe the jury could then infer. But the jury has to have that critical piece of evidence from a witness or a document saying that there's some share value, at least. That would be my position. The last point I want to raise, unless you have any other questions on that, is the interest question. The clerk computed interest at 12%. Here there's a contractual rate of 5%. That's in Section 4 of the agreement. And it allows the invoiced amount, which is $90,000, augmented up to $120,000 here, to collect interest at 5%. The rule of law that we cited in the brief is that when there's an obligation with a certain rate and it's not paid by the due date, the contractual rate continues after the obligation is due. And so, and if you look at the, I guess, volume 6 maybe, it's when the trial judge is talking to the counsel about the jury slip, and they take out, I guess there was a provision in there on interest, and the judge takes it out, but even then, he's also of the mind, if you read that, yeah, it's a contractual 5% rate. For whatever reason, the clerk used the 12 instead of the 5. So, unless the court has any more questions, that's
Seeing none, thank you. Thank you both.
Thank you.
Our last case is 23P467 O'Rourke versus Galil. Ms. Galil.
Good morning, Your Honors. May it please the Court. My name is Karin Galil. I'm the defendant and the appellant in this case, and I'm appearing pro se. I ask that you dismiss O'Rourke's complaint because it's time-barred, meeting no exception, because he materially breached our valid contract, which is a bar to recovery under both contract law and bars his quasi-contract claims, because he failed to meet the burden of proof for any of his claims, which is evident in his brief, where he says that his loss is, quote, self-evident, where it should be barred by the statute of frauds, which I raised, and he waived by not challenging, and most importantly, because he didn't suffer any financial harm, which the financial evidence proves. Adults in this Commonwealth have a choice. They can marry or they can choose not to marry, and that choice has profound legal consequences. If you marry, you've entered a fiduciary relationship, you've contracted to share your property and the assets you acquire.
Fiduciary relationships can operate outside of marriage.
Excuse me?
Fiduciary relationships are not confined to marriage.
They can. And if you divorce, you have a marital estate which is split equitably. If you choose not to marry, you remain independent. You can contract about your property and your finances. Your financial contributions cannot be considered gratuitous. So if you split up, your property cannot be divided equitably as in divorce. It has to be divided under the relevant contract and common law, and you have to prove your claims with objective evidence. I intentionally chose not to marry to preserve my independent legal rights. So when I read the judgment, I was shocked. Even though O'Rourke had filed a knowingly false, verified complaint almost 3 years after the statute of limitations had expired, had acknowledged our agreement to share our joint costs 50-50, but materially breached that contract and never cured it.
So can we talk about the statute of limitations?
Yes.
The judge made a finding of fact that Mr. O'Rourke didn't learn of the harm until 2017.
Yes, we can talk about that. So first of all, O'Rourke had what's undisputed is that he had actual knowledge of that injury at the time it occurred. He himself signed...
The judge didn't credit that. The judge said that he relied on your representation that it would be the house would be refinanced, and that you were in a fiduciary relationship.
Right. So the judge is correct that the judge is partly correct. I intended to reconvey the property after the financing. One thing that might be important to look at is an email that I sent a couple of months before that refinancing. There are a series of emails, they're cited in the brief, and they reiterate our agreement to share joint costs 50-50, and they point out that O'Rourke is failing, because remember, he is largely unemployed for the entirety of our relationship. So where's the money coming from to pay his half? I'm loaning him money repeatedly. But I make clear in writing, and these are in evidence, that my overpayments are not gratuitous gifts. They're loans that have to be repaid, and I even say potentially with equity. A couple of months before the refinancing, there's an email called Keeping versus Selling the House, and I respond to his threat to sell the house by pointing out that, you know, if we sell the house, we're not going to continue to co-own it. And if you read to the end of that email, it specifically says, that continued co-ownership, or it implies that continued co-ownership of the property requires two things: his payment of half our expenses going forward, and his reimbursing me for all the past imbalances. So the refinancing occurred in this context where I've already stated multiple times in writing that I'm overpaying him, that these are loans, that they have to be repaid.
You refinanced it in 2012.
Yes.
In your own name to get a lower interest rate.
I was forced to do it in my own name. There's a lot of evidence showing that I tried not to, but I did do it in my own name.
There's a question, all right? So,
Yes, sorry.
so the judge found that when that occurred, which required Mr. O'Rourke to convey his share of the property to you to get the lower interest rate, he never intended to relinquish his own interest in the property, especially without any consideration.
I would say, I can't say what his intent was. His intent may well have been to get off the mortgage so that he could...
One of the questions or issues I have with your appeal is that almost all of your arguments are based on your seeing the facts differently than the judge did. And an appellate court, I know you're pro se, an appellate court can't revisit findings of fact absent proof that they were clearly erroneous.
Okay,
well, they can't merely be your disagreement with the judge's view of the evidence.
All right, so what I would call your attention to is O'Rourke's own words. So at his deposition, when O'Rourke was asked about the refinancing and when he knew what he knew, hear his words. He said that it was, quote, clear to him by August of 2012 that the deed would not be reconveyed. He also said, and my testimony is almost identical, that starting about July 2012, when I found out that he was going to leave me on the hook to pay everything and not pay the mortgage, his testimony is that, quote, we discussed the status of his equity dozens of times in the years after July 2012, and that on each occasion, I told him unambiguously that he had no ownership interest left because I had fully repaid his equity. So that's his testimony at deposition. I think what happened is between deposition...
Did that come out at trial?
That is in the trial record, and it came out at trial. Part of
Same testimony came out at trial.
The testimony is there. There was a little bit of a wrinkle because my lawyer, I was represented by counsel, my lawyer gave in the deposition testimony. It was not marked. We had to go back for a post-trial motion to have it included as, I think, Exhibit 136, et cetera. But it was summarized at trial, and it is part of the record. So then he comes back at trial and changes his testimony to claim he had no idea, et cetera. That is a drastic alteration of his testimony under oath. And I would also say that the case law doesn't support it. The case law around statute of limitations is that it is, first of all, he had actual knowledge. Actual knowledge starts the clock even in cases of fiduciary duty. That's passatempo. And moreover, the courts have addressed the issue of when does the clock start for a permanent injury? It doesn't start when you recognize the injury is permanent. It starts as soon as you're put on notice. So as soon as there's a suspicious circumstance, somebody, you know, and his notice was actually, there's no way he didn't know. He acknowledges that he knew he was signing his interest away.
He knew what he was doing as far as conveying the property to you, but the judge found that he did not realize that you were not going to reconvey it back as you had promised him.
His own words and our repeated arguments, and my testimony and his testimony on this one point align perfectly, is that we discussed his equity dozens of times. My testimony was dozens of times, about every other month. His testimony is dozens of times. Starting in August of 2012, we argued about his equity, and on each occasion, I told him unambiguously that he had no ownership interest.
The judge did not credit your testimony.
Well, the judge should credit O'Rourke's testimony.
You told us just now that he testified that he did not know. You said he changed his mind.
He changed his testimony. But O'Rourke's own testimony in his own words is in the record. And so I'm not asking you to believe me. I'm asking you to believe him. And he had been warned, this is in a context, he had been warned in the years of emails leading up to this, because I was overpaying expenses, that these weren't gratuitous gifts, these were loans that had to be repaid, that continued co-ownership of the property was predicated on his paying his half.
Now, the judge found that his payments between 2002 and 2012 were offset by your payments of other expenses.
Well,
The same was true of the O'Rourke's post-2012 contributions, but what's your best evidence that those post-2012 contributions were insufficient?
My best evidence is 14 years of near-complete bank records that are in the record appendices books. And even if we credit all of O'Rourke's claims, remember his claims come from spreadsheets, hearsay, which he altered after filing his complaint to inflate his claims. But even if you credit all of them, and you compare them to bank and credit card records that I submitted into evidence, which show what I actually paid, he owed me more by the time we refinanced in 2012 than his equity in the property. So that would be, and to address the issue of the factual findings, first of all, the judge's factual findings are based on, or should be based on, documentary evidence. So this court can review documentary evidence de novo. And secondly, I think at a very high level, the judge basically used marital law and came to a, let's split this baby like a marital asset, and then chose not to look at the relevant evidence. The judge's own words before I even testified to financial matters was that an accounting action was, quote, a waste of time. And I think there's one other factor that I should raise, which is that if you read his judgment to the end and the things I've quoted from what he said at trial, the judge himself said, oh, I can't look at this in isolation. I have to consider a partition action in Rhode Island and a custody case. And so he made assumptions about two lawsuits not in evidence to conclude that we had some sort of quasi-marital joint enterprise. So his financial conclusions are based on, and that's reversible error, are based on making assumptions about matters not in evidence, and they are based on literally just refusing to actually look at the evidence that was before the court. And I think that's the reason that we ended up with a constructive trust and not the monetary damages that O'Rourke requested. Why couldn't they give him money damages? He wanted them, full remedy at law, because there's no basis to give him any. He provided no evidence whatsoever to show his loss or my gain, and all the evidence that's in those exhibit books proves that he made out. I mean, he wasn't working. He's spending 15 years living there. He has a job at the very beginning. After that, he's doing a little light consulting and, pursuing hobbies. One of us is working, and the bills are coming in. So even on its face, it's rather implausible to think that he was paying anywhere near his share. But you don't have to believe me. Again, I just refer you to the documentary evidence and my emails. And I'd like to kind of make one more comment about statute of limitations. So I'll start with constructive trust. I think the problem with a constructive trust is it guarantees that the miscarriage of justice in this case will be perpetuated, because he starts that case as the half owner of the property. So there's an improper shifting of the burden from him, where he didn't meet it in the lower court, to me, who now has to disprove his right to half of my property. So that's one problem. And then the second and greater problem is that a partition court, busy partition court, is just going to say, oh, we don't want to look at all this evidence again. We're just going to rely on the probate court's findings, even though they are unsubstantiated and, frankly, erroneous. And, I lose half a house that I have put over $1.3 million in its paying down the mortgage, renovating and enlarging since 2012, let him live rent-free. So I think this is a massive miscarriage of justice. I also think that the argument that I'm simply seeking to relitigate on appeal is inaccurate because most of the arguments I make in my brief are actually about matters of law, or they refer to factual findings that are either reviewed de novo, is there a contract, was there a breach, is there an enforceable promise, or else they're based on documentary evidence, which this court can review de novo. Thank you.
Thank you. Ms. Sweet.
Good morning. Attorney Sweet on behalf of, Edward O'Rourke. I wanted to start off with a very brief statement that is found in the trial court's findings of fact, and it is this. It was the defendant's wrongful behavior that necessitated this action. So, but for Dr. Galil refusing to act on her promise to reconvey the deed back to my client, we wouldn't be here. We wouldn't be here. My client would have spent over $150,000 trying to get back his half interest in a very valuable piece of real estate in Winchester, which, according to the appraisals done back at the time of trial, which are now outdated, had a value of somewhere between $1.4 and $1.6 million. To say nothing of...
Well, the judge took judicial notice that the property has increased in value.
Exactly, Your Honor. And so that goes quite directly and contrary to Dr. Galil's representations that my client hasn't been harmed by her behavior. I mean, it's just incredulous that she could say that with it, given the fact, given the fact that he no longer has 1/2 interest in this property, which could be maybe even $2 million by now. So as the court is aware, the trial court imposed a constructive trust on 3 theories of legal theories: promissory estoppel, breach of fiduciary duty, and unjust enrichment. Contrary to Dr. Galil's representation, the standard of review is not de novo. It is abuse of discretion that was established by the U.S. versus Ramuno case. When there is an imposition of a constructive trust, it is reviewed as for abuse of discretion. And I also want to address directly off the top her argument about the statute of limitations, since we sort of need to address that before getting to the substantive matters of the case. Of course, she alleges that my client knew or should have known about the harm back in 2012 when the refinance first occurred. That is not consistent with the facts. The facts are uncontested that there was a promise by Dr. Galil that after the refinancing, she would restore his name to the deed. She agreed to that. She testified under oath at her deposition. She testified at trial. So right there, all the other excuses that Dr. Galil has come up with at trial and before the court today are irrelevant. There was never an intention by my client to permanently waive his interest in this property because, frankly, Your Honors, if he had known that, he would not have signed the deed. It's as simple as that. He trusted his life partner, whom they shared 2 properties together, a child, had lived together since 2002. He believed her. He believed the promise. And he relied on that promise to his severe detriment. And that is essentially what promissory estoppel is about. You have a plaintiff who relied on a promise, and then that promise was not followed through. And again, we're here today. The court, as you know, further found that there was a breach of fiduciary duty between the parties. Yes, they were not married. My client never claimed that they were, didn't try to make this a marriage. That was Dr. Galil's argument that he was trying to do that. We're relying on the case law that this Commonwealth has set down that does recognize certain rights in certain circumstances between unmarried cohabitants. I think the most relevant case on point is the Bonino versus Shepard case.
I'm sorry to interrupt, excuse me. Would your argument be any different if they were not fiduciaries?
Well, I think it takes out, excuse me, I think it's very relevant that they are fiduciaries, Your Honor.
No, you misunderstood my question. What if they are not fiduciaries? Does it change your argument?
I don't know how I can separate that, Your Honor, because factually, that's what they are, and it's very relevant to how the court views the facts of this case. I mean, this is not an arm's-length transaction from strangers.
Would they have to be fiduciaries for promissory estoppel to operate?
No, I'll answer that question directly. Thank you for phrasing that. So getting back to the facts that there's a line of case law where there are, under certain circumstances, yes, there can be unmarried but co-own a property, and if the facts suffice, as in the case here, one party could have some sort of equitable form of relief. You know, one of the possible forms of relief is obviously the constructive trust, which was imposed here. There's also restitution, which was one of the competing factors that was another account that my client had filed, and the trial court found that because he had chosen to impose a constructive trust, restitution would have been sort of double dipping. But restitution is what's at point in the case in the Bonino versus Shepard case, where in that case the plaintiff was actually repaid the dollar amount that he had put into the property that he lived in with his life partner. Now, obviously, in that particular case, one of the main factors was that the defendant's name was the only ever name on the deed. In this case, we have property that the two parties' names were on the deed in 2002 when they purchased it. It was on it when they refinanced the first time in 2005. They were both on it when they refinanced in 2010. It was only in 2012 when the only reason, again, this is uncontested, the only reason there was a refinance is that Dr. Galil wanted to take advantage of a lower rate. There was no other reason. There was no her revisionist history, there was no argument that he was using up his equity. There was no argument that he owed me money. I will point out, up until that point, for the first 10 years, Dr. Galil was reimbursing my client for expenses that my client paid my client.
The judge ordered the property transferred to the two of them as tenants in common.
Correct.
But he didn't say anything about the mortgage that's only in Galil's name. Is that only her debt?
Well, I think it's a secured debt against the property.
I'm sorry, again, I missed that. It's a what?
Right, it's only her name. The trial court didn't really make an opinion on that. The trial court,
that's why I'm asking.
right. Well, the trial court observed that he couldn't really comment on that because there's also the flip side, which my client has been denied the use, occupancy, enjoyment of a property since he left in 2017. When she changed the lock. So there's also that to be considered. And are those competing equities? I think he also referenced too that
Let me try again. Mm-hmm. So they own the property as tenants in common per the judge's order, or will own it as tenants in common. And there's a mortgage on the property.
Correct.
That's only in her name.
Correct.
And is that her debt alone?
Technically, as it stands right now, yes, it's individually in her name alone. My client's not.
Is there an offset for that debt?
The trial court did not get to that level of discretion and said, in fact, that would have to be, I believe, addressed in a petition for partition if the parties could not, agree on a buyout once they co-owned the property. So I don't believe that was addressed on the record, Your Honor.
No, I know. That's what. That's why I keep asking you about it.
Yeah. Well. A fair question. I don't know that we can, on this record, have an answer to that because there's also, as I said, the competing factors of the fact that my client has been denied the use and occupancy of this, to say nothing of his personal property, the bulk of which remained at the home, and he was unable to get.
That's what I asked. Those would have to be determinations of some sort of offset that would his loss of use and enjoyment of the property offset her mortgage, but we can't make findings here.
Exactly, Your Honor. So I ill-equipped to answer that particular question because I don't have the data.
What about the kitchen renovation?
I'm glad you brought that up because that was actually the next thing I was going to tackle.
Well, let me ask the question.
Yeah.
So the kitchen renovation, depending on who you ask, cost as little as $200 and as much as $500. Mm-hmm. And he didn't contribute to any of that. Is that correct?
That is not correct. In fact,
right.
The record reflects that he continued to make capital repairs. I don't have the timing of everything he did, but it's all in my brief, Your Honor. He also continued to buy some ovens. He bought Bluestone. He rented trucks to go pick up items that Dr. Galil wanted.
What about the roof, the $52,000 roof?
So that's unclear. That also gets commingled with the fact that Dr. Galil received substantial insurance proceeds under an insurance policy, which both of their names were on, kept my client completely in the dark about that, and retained to herself a check in excess of $36,000, which, again, my client didn't know about until we did discovery in this case in 2018. But to directly answer your point about the kitchen remodel, you don't need to rely on testimony. Look at Exhibit 108, which is part of the underlying record. That was Dr. Galil's, and she characterized it, expenses for kitchen renovation. I urge you to look at it. There's no 500, 700,000, whatever. The documents that she put in only substantiate that figure of roughly $260,000. The total receipts total about over $300,000, but in cross-examination, when you actually look at the receipts, there were duplicates, there were estimates, there were things outside the kitchen renovation, some things that happened earlier in time, later in time. I mean, one was a $13,000 air conditioning unit, which the parties jointly paid for from their joint bank account. This was all admitted on cross-examination. So that revised chart that I submitted in my proposed judgment, which is also part of the record, and includes a chart, which I color-coded. So everything in yellow is the stuff that she admitted on cross-examination was not part of the kitchen renovation. So when you get down to actually looking at those receipts, the receipts for kitchen renovation that Dr. Galil herself submitted were only the $260,000 figure. And again, that's something to be weighed in the future, because as trial court observed, there was no evidence in terms of, well, how much did that particular kitchen renovation actually increase the fair market value of the property? We don't know from the record at that point in time. So I just want to go back, excuse me, Your Honors, and really talk about something that this court started out questioning when Dr. Galil was before you, and this is quoted in my brief. The bulk of her brief is just asking the court to substitute her own judgment and how she sees the facts versus how the trial court saw the facts. And where the fact findings and the decisions of credibility that were made by the trial court, if they have been reasonably drawn from the evidence presented, then they are not clearly erroneous. And I would submit, Your Honors, that Dr. Galil cannot sustain that burden. This was 4 days of trial, extensive exhibits. We had over 7 full binders of documents that were not just my client's Quicken reports. They were bank statements. They were credit card statements. There were 69 emails of the parties. After hearing all the evidence and weighing it, the court found, first of all, that she agreed to redeed it to him. And in fact, 4 days after my client signed the deed over to her, she actually initiated the closing attorney and said, "Can you send me a draft deed to restore my client's name to the property?" She received the email, but of course, never signed the deed. My client testified that it's true that in August of 2012, after the refinance, he said he was aware that she was not going to restore his name to the deed. But what Dr. Galil conveniently and has always and has consistently ignores and omits, because it doesn't fit her version of the case, is then he followed it up with saying, "I knew that I would then get my name put back on the deed the next time we refinanced." So she only wants to look at the first part of his testimony and ignores the second part, and then says my client has changed his testimony, which nothing could be further from the truth. Something else that I want to comment on that Dr. Galil had indicated was that my client supposedly altered the evidence and altered the data. This is the same exact argument she put forward at the trial court. My client did not alter any data. He admitted from the get-go that a couple times he recharacterized different categories of living expenses to make it more clear as to what the money was spent for. He never altered the date, the amount, the vendor, what it was for. So I would just like to point that out. Dr. Galil referenced and asked the court to look at the emails between the parties. I too would urge you to do that, because part of the issue here is she's saying, I told him he had no more ownership interest. Well, and in fact, that's just actually not true if you look at the timing of those emails. And what's also noticeably absent and very conspicuous is she never put in writing anywhere, "I will not convey that property back to you." This from a woman who regularly sent emails to her life partner. It was a traditional way of communicating with him. The volume of emails was tremendous. She sent him emails about all types of life topics. But this one important topic, she never put it in writing. I think that's significant, and there's a reasonable inference to be drawn by that. Similarly, how when she finally did refinance in December of 2012, so this is the same year of the refinance that removed my client's name, she sent him several emails about the refinancing with respect to the Prudence Island property that they co-owned. He was copied on all of those deeds. She simultaneously, and without my client's knowledge, refinanced the Winchester property. She never copied him on any emails to her broker. And that's in evidence, Your Honors. Why not? It's a really good question. And it supports and underscores the finding by the trial court that gave credence to my client's testimony that he truly believed his name would get put back on that deed when they next refinanced. And it didn't happen. And finally, when he ended the relationship in 2017, that's when he realized, this woman is never going to put me back on the deed, and I need to do something about it. And then he filed suit in 2018, shortly after that. So that's when he realized the harm that he suffered. He lost his interest in a very valuable property, which he had put down. The down payment alone was over $300,000. He put down 70% of the down payment. So in closing, I know I'm running out of time. I would just ask the court to look at the record, because the record supports the credibility and the fact findings by the trial court. I'd also like to bring up, because I think it's outrageous that my client has had to go through what he's had to go through to get here today, as I would just ask the court to consider my motion for appellate fees. And I filed a motion back in June and a subsequent affidavit in support of same, because he shouldn't have had to spend this amount to try to get back what's rightfully his. Thank you.
Thank you. Thank you both. We'll take that under advisement. With that, I'd like to thank our court staff, our court officers, our clerk's office, our law clerks, and our excellent timekeeper, and we will stand in recess.